Speaker is Sandra Park, Chairperson of Domestic Violence Committee, New York City Bar. And while she's coming, I'd like to prepare William Gibney, Director of Special Litigation, and Hannah Shapiro, Attorney for Civil Practice in Brooklyn Legal Aid Society, as the next two speakers.
Thank you so much for the opportunity to participate in today's forum on behalf of the New York City Bar Association. My name is Sandra Park. I work at the ACLU Women's Rights Project, and I
Excuse me, just one second, I apologize. I didn't want Ms. Griffith to leave. Did you say that we had a copy of your statement? Yes. You do, okay. All right, I just wanted to be sure. And just in the event that it somehow got misplaced, could we ask you to share your copy with us so we can make copies and we'll return your original? Thank you. I apologize. Please continue.
No, that's fine. So I chair the City Bar's Committee on Domestic Violence, which engages in policy and legal analysis, and also engages in attorney and public education. And our members are employed in a variety of arenas, but all of them work with domestic violence survivors in some capacity. The City Bar is speaking today to support legislation addressing housing discrimination against survivors of domestic violence, as well as in support of the Domestic Violence Survivors Justice Act. We believe that enacting laws addressing these issues would strengthen our state's recognition of the myriad ways that domestic violence impacts victims, such as in housing and the criminal justice system, and we therefore urge that these bills be passed. The City Bar has long advocated for legislation to include victims of domestic violence in state laws prohibiting housing discrimination. The need is particularly compelling with the ongoing economic and housing crises. Victims of domestic violence frequently lose housing due to discrimination based on their status as victims. They often face eviction based on the violent acts of their abusers or because they have sought protection from the police and/or the courts. They also report being denied housing due to their past experience as victims. And the way this often plays out is that many landlords and management companies penalize an entire household for criminal activity occurring at the property pursuant to zero-tolerance policies or other crime-free policies. And when that occurs, victims are likely to be evicted when they reach out for police assistance, because that is the precise moment when landlords become aware of the abuse. The U.S. Congress, in passing and reauthorizing the Violence Against Women Act, has recognized that evicting victims is a common response by landlords to domestic abuse. Congress also found that this response has serious consequences for women and their children who are dealing with violence, because many victims may decide to stay silent about the abuse they are experiencing in order to avoid losing their housing. Studies have repeatedly found that domestic violence, including related housing discrimination based on abuse, is a primary cause of homelessness for women and families with children. Yet without the security of safe and affordable housing, victims of violence and their children lack a critical tool that they need to leave a dangerous situation. Proposed legislation such as S-6994 and S-3784 would address housing discrimination against victims by amending the state's human rights law, Section 296 of the executive law, to add victims of domestic violence to the list of groups protected from housing discrimination. Such an amendment would make it unlawful for a landlord to refuse to sell or rent or to discriminate in the terms or conditions of providing housing based on status as a victim of domestic violence. The City Bar has endorsed S-6994, which would amend Section 292 of the executive law to cross-reference the definition of victim of domestic violence with the definition currently found in the social services law. And that is the definition used to determine who qualifies for domestic violence services, and has already been updated to incorporate the family offense definition from the Family Court Act. Significantly, legislation of this nature would fill a gap in VAWA. VAWA currently protects victims of domestic violence, stalking, and dating violence from discrimination and access to public public housing and Section 8 housing, and provides those victims with defenses to eviction. Since its enactment, VAWA has helped preserve the housing of victims, including those living in New York. One of the first published cases dealing with the enforcement of VAWA rights arose in New York City, where a court concluded that a Section 8 landlord violated VAWA when trying to evict a tenant based on domestic violence perpetrated against her. However, these protections do not apply to victims living in private housing that do not receive a Section 8 subsidy, which is the vast majority of housing. Because of the temporary nature of shelters and the shortage of public housing and subsidized housing in New York, numerous victims fleeing their abusers seek shelter in the private housing market and thus are not currently afforded any legal protection. Extending anti-discrimination protections to victims would not impose an undue burden on landlords. Like other anti-discrimination laws, the bill prohibits adverse actions against tenants only when those actions are taken on the basis of an impermissible discriminatory reason. The bill would only protect a tenant who is discriminated against because of his or her status as a victim of domestic violence. The District of Columbia, Indiana, North Carolina, several other states, and Westchester County, New York, already have enacted laws prohibiting housing discrimination against victims of domestic violence, and we urge New York to follow suit. The City Bar also supports the Domestic Violence Survivors Justice Act, which would amend New York's penal and criminal procedure law, as we've heard today already. Abusers use violence, fear, and control to manipulate their victims, including manipulating victims to commit criminal activity directly leading to their present incarceration. Many incarcerated survivors have committed criminal activity to protect themselves from further violence, and others have convictions stemming from acts taken as a result of an abuser's coercion. As we've already heard today in some very compelling testimony this morning, and as the report from Protection to Punishment established, survivors do end up with convictions and long prison terms for criminal activity arising from the abuse they experience. The consequences to children and society are especially severe when victims of domestic violence are incarcerated, because they are no longer able to have the same sorts of relationships with their children when they are separated by prison walls. New York taxpayers do not fare much better as a result, as they are often left to pay for both the children's care and the hefty cost of incarceration. Currently, although New York law may permit a defendant to raise duress or self-defense arguments prior to conviction, the law fails to give judges discretion to ameliorate sentences for domestic violence survivors who are defendants. And most violent felony offenses and some higher-level nonviolent offenses carry mandatory prison penalties, which constrain the judge's ability to sentence taking into account domestic violence and its effects. The exception in Jenna's law, which was passed in 1998 and ended parole for most people convicted of first-time violent felony offenses, does not adequately address problems that arise with sentencing of domestic violence victims. The exception allows judges to impose indeterminate sentences and thus preserves the possibility of parole for survivors convicted of crimes against their abusers. However, the provision has not accomplished the goal of more compassionate sentencing for domestic violence survivors because it only applies to certain homicide and assault offenses and only where the abuser is the victim. Furthermore, it does not allow judges to sentence defendants to alternatives to incarceration programs and can actually result in longer prison terms. The bill in no way diminishes the seriousness of criminal activity because it deals with sentencing. It's not creating a defense to the charge. It includes appropriate safeguards such as a judge would need to make specific findings regarding a defendant's status as a victim who was subjected to substantial abuse at the time the crime was committed, that the abuse was a significant contributing factor to the crime, and the harshness of a sentence under the generally applicable provisions. And the prosecutor would have the opportunity to object to the alternate sentence under the facts of a particular case. Thus, the bill would not allow defendants to claim that abuse from a time prior to the commission of the crime or that abuse unrelated to the commission of the crime would make them eligible for alternate sentencing. Moreover, the judge would always have the discretion to deny an alternate sentence, even where a defendant showed that he or she qualified under the first two factors, if the judge believes the sentence under the general sentencing guidelines is appropriate. For all of those reasons, we believe that S5436 is a step forward towards achieving fairness in New York's justice system for survivors of domestic violence, and will also save taxpayer funds in these difficult financial times. Most importantly, it acknowledges the role that abuse can play in the commission of crimes and allows survivors to maintain ties to children and other family members who have already been traumatized by domestic violence.
Thank you.
Thank
Are
you.
there any questions?